be left undisturbed and their sovereignty would be intact. But of course, the settler regimes continued to come in waves and groves and settled in lands that were contested, that were not set aside for the encroachment of international newcomers. So what eventually happened is that Pontiac rose up war troops and began to burn down British forts. And in doing so, this alarmed the Crown, because at that time, if all Native nations had allied together, they could pose a very powerful military force, as well as a threat. The Crown, knowing this, basically said it is better to have the Indian people as comrades and as allies, both militarily and commercially, than to have us as enemies. In fact, we were being used, in a sense, as military reinforcements to stop the U.S. colonists, the revolutionaries, from annexing Canada to the United States. Now, King George then came up with the 1763 Royal Proclamation. In the proclamation, it said all lands should be left unmolested and undisturbed, meaning the only way that the Crown could get the lands from Native peoples was through direct surrender of the land. And I was talking with my friend here, Janice, and we were talking about the pros and cons of the whole concept of surrendering land, both on a commercial level and as well as not necessarily so much in terms of a military level, or to be compensated for the land in monetary sense. And if those terms hadn't been met, then the contested lands of any Native peoples throughout North America that had not entered into this kind of international agreement, which is what the 1763 is, in actuality is international law. Once the Queen, at that time, or the King at that time, King George III, signed that proclamation, it went over to the British Privy Council, and they signed it into law as an act that was delegated and sanctioned by the British people. So it now stands as international law. So then we go down, by the way, and a lot of people don't know that one of the major reasons why the U.S. colonists fought the so-called War of Independence in 1776 was because they were completely angry at the fact that King George was trying to extrapolate a tax from the American colonists to pay for the Canadian military to protect the terms of the 1763 Royal Proclamation. In other words, to protect our sovereignty as a people. So they said, hell with that, because we intend to pay pennies per acre to Indians in this U.S. that's not known as the United States. And if they don't like it, then we'll enact a policy of direct compensation through arms, and they in fact killed millions of Indian peoples in a process known as manifest destiny to get those lands and those resources. To Canada's credit, Canada did not have the same blood intent out of greed to take Indian lands in the same fashion through military arms. There had been a number of skirmishes and there had been blood, and these laws have been written basically on the blood of our ancestors. But Canada, to its credit, was more willing to work on a military commercial level as allies than as enemies. And so then we say we got to constantly reaffirm this historical relationship between the indigenous peoples of North America and the Crown, and to remind all of our relations that don't understand this law what this law means. Then moving straight down into history, we go to 1982, when Pierre Elliott Trudeau and the Queen of England, Elizabeth, sit down and they sign the patriation of the Canadian Constitution. And under Section 35 of the Canadian Constitution validates and enshrines in the Constitution the protection of Aboriginal rights, including those relative to the 1763. Now, whenever you hear about treaty making going on, and I'm not necessarily talking about the number of treaties right now, but I'm talking about right now, predominantly British Columbia and other places they're trying to make treaties, you're always saying that, yes, we have to deal with the question of Section 35, the protection of Aboriginal rights, those that are enshrined in the Constitution. But they don't ever say, including those relative to the 1763, because the 1763 is international law. So you've got a constitution that validates international law, which is basically says we are sovereign, self-determining people. And until we give that sovereignty away, we will continue to be a free, independent, sovereign people. That's the way the law reads. So when they decided they were going to evict us, and we raised the law to South Lake, that was the basis on which we wanted to get the Canadian people and the international community to know that this is the law that we were standing on. If the rule of law is not a cruel hoax, and if the rule of law is not just an illusion to cover up for the rule of force by governments against the indigenous populations, then on a nation-to-nation, human-to-human basis, we have to have that respect. Most people don't understand the law, so this way it's necessary to educate the law in order to have a nation-to-nation respect, people-to-people respect, and to reinforce the concept of the rule of law. But ignorance, which is basically fostered harms, leaves so much open to misunderstanding, which causes a lot of conflict. And this is what we're basically in as a people, nation to nation, trying to weed out the idea of the question of data sovereignty and what this treaty making is really all about. So, understanding this, that we would understand, next thing that we understood is that the reason that they want to fast track the treaty making processes in British Columbia and across the board is because there is another law-making body that has surfaced and raised its ugly head. And that is called the World Trade Organization. That is called the bilateral agreement between Canada and the United States and the NAFTA, the terms of the NAFTA, the Free Trade Agreement. And what we're dealing with now is the rise of a one world corporate economic order that wants to become the dominant national and international law. Such to the effect that under Section 11 of the Free Trade Agreement, the NAFTA Accord, makes NAFTA the supreme arbiter, meaning that anytime any of the resources come into question, which are predominantly in unceded Indian land, 60% of the resources of the 33 major natural resources of North America exist in our territories that are still contested in terms of land claims. On the question of title. And so NAFTA has got to get rid of those, they fast track the treaty, they got to get rid of that federal and provincial obligation that they have to us in terms of title, so that we can come under the rule of corporate law. Which is by so many of the bands, the elected system, which is an imposition government, which is neo-colonial puppet regimes that have been forced upon us. But this is why they're forcing bans in order to start setting up to become incorporated so that they can eventually come under NAFTA law, under the World Trade Organization. And so as we turn around and we look around, all of a sudden different so-called reserves, which I prefer to call nations, are being subjected to somebody coming in and taking the resources, and deals are being made by the Grand Chief and Councils, and all of a sudden people turn around, they got no more land, they got no more resources, and everybody's forced into the urban society, and all of a sudden we're not independence on the welfare state in this government, and before you know it, we've got nothing. We're on a death trap. We're on a track for our own annihilation. And look how many of our people are in the cities. Look how many of our people are lost in these cities. On drugs, on alcohol, on prostitution, on hustle. I was one of those guys. I was disenfranchised. I was a city guy, a New York boy. But I went through the pits, the turf, the gang wars, the hustles. I came through the worst to try to survive and it landed me in prison. So we brought this title. We're trying to bring out the title. What does this title mean for our people? How can we clarify this to our relations to newcomers and non-native peoples? How can we get people to understand this? Because we came out with the question of title, and we clarified title into degrees. We gave clarity to the definition of title and the law. From that point on, and we did that at that point through the person that was really in our corner in defining the law to us, was a brother by a man by the name, a newcomer by the name of Dr. Bruce Clark, who was a PhD and had been studying international constitutional aboriginal law for 26 years. But the Canadian government would then go on a major campaign to discredit him, to make him look like a kook and somebody from outer space because he had these designer glasses and a bald head. But what has that got to do with the law? My goodness. Ridiculous, low-level smear and disinformation. They have reduced this man to a pauper. Here's a man that had millions of dollars in his own law practice. Here's a man that had an airplane he could fly around the country with. He had a big luxurious home over there in Ottawa. And because he came to fight and work for Indian peoples, he's been reduced to a welfare recipient today as we talk. He owed $19,000 in taxes while he was working with the Mi'kmaq up in Restigouche. And he refused to pay the government the $19,000 because he was adopted by the Mi'kmaq. So he refused to pay the $19,000 in taxes, and the government now tells him he owes $258,000 in penalties for $19,000. And until he pays those penalties, he'll never get his license back to practice. The man has been crucified economically because he stood with us. There was a time in Canadian law that if a lawyer helped Indian people on any land claims, it was illegal. They would go to jail for 10 years up until 1951. What is that all about? That's the question. What is that all about? So here is the law that we stood on, and because we stood on this law, the reaction of the provincial government, at that time there was an attorney general just came into office, his name was Ujjwal Dosanjh. When we made that decision, through that line in the sand, the response by Ujjwal Dosanjh was the call for a military operation against South Soleil. Ujjwal Dosanjh met with a guy by the name of Sawyer, who was a major from the Canadian military forces. And after he met with them on August the 19th, we had been in a defensive posture. We had had rednecks come in and start shooting into the camp, almost killing our children, in a peaceful defensive posture. And after the skirmishes, and I always said, never shoot at them. When you shoot back, never shoot at them to kill. Shoot over their heads to warn them not to come any further. But we were going to get that title out there one way or the other. And it was going to be heard on a national and international level. And sure enough, when we tested that particular sense of defense, never an offense, we were always protected from a spiritual source. And as we did this, a number of confrontations happened. Eventually, Ujjwal Dosanjh would order a special anti-terrorist commando squad known as the Joint Task Force 2 to go into the camp and to seek out Wolverine and myself and eliminate us. That was their job, to eliminate Splitty the Sky and Wolverine. Now what they didn't know is, by this time, we were already trying to set up a meeting with Lyle James and his lawyer, whose name was Bruce Mack. He was also affiliated with lawyers from a group called, a law firm called Ladner Downs, which is the same law firm John